If this was useful, there's a lot more where it came from. Other specific situations, other specific rights, all covered with the same care we're putting into today's topic. Subscribing is the easiest way to make sure you don't miss the next one, especially since a lot of these topics tend to become relevant exactly when you least expect it, which is exactly why it's worth having them ready in advance rather than scrambling to look them up in the moment. All right, let's keep going with today's topic. You're walking down the street. Maybe it's midday, maybe it's evening, maybe you're coming back from a coffee shop or heading to your car, or just cutting through a neighborhood you've walked through 100 times before. And then it happens. An officer steps toward you, makes eye contact, maybe holds up a hand, and says those words, "Hey, can I talk to you for a second?" And in that exact moment, before you've processed what's even happening, a decision starts forming that most people get completely wrong, not because they're careless, not because they don't care about their rights, but because nobody ever sat them down and explained what that street encounter actually is, legally, and what the one rule is that changes everything about how you respond to it. Here's what I want you to walk away from this video knowing, cold, without having to think it through under pressure. A police stop on a public street is not automatically what most people assume it is. There are different kinds of street encounters, and the kind of encounter you're actually in determines everything. What you have to do, what you don't have to do, what you can say, what you should not say, and most importantly, what the single rule is that you need to understand before you explain a single thing about yourself, your destination, your reason for being where you are, or anything else. Because explaining first, before you know which kind of encounter this is the mistake that quietly costs people the most. And it's the mistake we're going to make sure you never make again starting today. Before we get into exactly what that one rule is and how it plays out across every version of this scenario, if you want to actually know how these encounters work, instead of just hoping for the best the next time someone in a uniform steps toward you on a public sidewalk, subscribe right now, because this is exactly what this channel is built to give you, real information laid out clearly, so that when the moment comes, you're not inventing your response from nothing. Quick note before we go further. This is legal education and commentary, not legal advice for your specific situation, and certain details shift from state to state, but the core principles we're covering today hold up across virtually the entire country. Let's get into it. Let's start with the foundation, the piece that makes everything else make sense, because without this one underlying concept, all the specific advice in the world won't quite fit together properly in your mind. When an officer approaches you on a public street, the very first thing that matters legally is what kind of encounter is actually happening. And here's what almost nobody knows. Not every encounter with police on a public street is the same kind of encounter, and the differences between them are not small. They are enormous, and they determine what you're actually required to do. There are essentially three kinds of encounters you might find yourself in when police approach you on a street, and they each live at a very different point on a legal spectrum. The first kind is what courts have called a consensual encounter, sometimes also called a voluntary contact, and it's exactly what it sounds like. An officer approaches you, says hello, maybe asks where you're headed or what you're up to, and the entire thing, from a legal standpoint, is voluntary. I want to be upfront about something, because I think it's important to say directly, rather than bury in a quick disclaimer. General legal education, including everything we do here, has real limits, and it's worth understanding exactly where those limits are. What we can do here is give you a strong, accurate, genuinely useful foundation, the kind of understanding that changes how you experience a real situation when it happens. What we can't do here is account for every specific variation, every local nuance, every unique detail of your particular circumstances, because that's simply not something general content is built to do, no matter how thorough it tries to be. That's exactly why the foundation matters so much, though. A strong general understanding is what tells you when a situation is straightforward enough to handle with what you already know, and when it's specific and serious enough that it's worth bringing in someone who can look at your exact circumstances directly. All right, keeping that framing in mind, let's get into it. You're not required to stop. You're not required to answer. You're not being detained. You're free to walk away, free to politely decline the conversation, free to say nothing at all. The legal standard here is essentially the same as if a stranger on the street walked up and started asking you questions. You can engage, or you can walk away, and either choice is completely legal. The officer is allowed to approach you and start a conversation, and you're allowed to not have that conversation if you don't want to. The second kind is what's called an investigative stop, and you've probably heard the legal term for this one, a Terry stop, named after a 1968 Supreme Court case called Terry v. Sur, Ohio, which established that officers can briefly stop and detain someone without making a full arrest and without having full probable cause for an arrest if they have what's called reasonable articulable suspicion. That phrase matters more than almost anything else in this video, so let's sit with it for a second. Reasonable articulable suspicion means the officer must be able to point to specific, objective, articulable facts. Not a hunch, not a feeling, not a general sense that something seems off, but actual, specific facts that would lead a reasonable person to believe criminal activity is occurring, is about to occur, or has just occurred, and that this specific person is connected to that activity. If those specific facts exist, an officer can briefly stop you, briefly detain you while they investigate, and in some circumstances, conduct a limited pat-down of your outer clothing if they have reason to believe you're armed. But even then, even in a legitimate Terry stop, there are very clear limits on what they can do, how long they can hold you, and what kind of information you're actually required to provide. We'll walk through all of that carefully in a moment. The third kind of encounter is a full custodial arrest, where you've been placed under arrest, you're in custody, and the full weight of your Miranda rights attach, the rights you've heard recited on every police procedural you've ever watched. You have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney, and if you can't afford one, one will be appointed for you. At that point, the encounter has taken on a fundamentally different legal character, and the rules operating around it are correspondingly different. Now, here's why this three-part framework is the absolute foundation of everything in this video, and here's the one rule you need to understand before you explain anything. Before you say a single word about who you are, where you've been, where you're going, or what you've been doing, you need to know which kind of encounter you're actually in. Because the answer to that question determines whether you have any obligation to respond at all, and the specific way you figure out which kind of encounter you're in is simple, direct, and something you can actually use in the moment. You ask. The question is, am I free to go? That's it. That is the single most important question you can ask when an officer approaches you on a public street, and you should ask it before you explain anything, answer anything, or offer any information at all. Am I free to go? Is not rude. It is not aggressive. It is not evidence of guilt. It is a precise, legally meaningful question that cuts through any ambiguity about what kind of encounter you're actually in, and the answer to it tells you everything you need to know about how to proceed. If the answer is yes, you're free to go, then you are in a consensual encounter, and you can politely end the conversation right then and there. You can say thank you and walk away, and walking away in that moment is entirely legal, completely appropriate, and actually the smartest thing you can do, not because there's anything wrong with talking to officers in general, but because you've now identified that the entire interaction was voluntary, which means you had the right to opt out of it from the start, and exercising that right the moment you confirm you have it is simply sensible. If the answer is no, you're not free to go, then you've moved into a different legal space. You're being detained. And now a whole new set of rules applies, and we're going to walk through every one of them carefully. But the critical point is this. You now know what kind of encounter you're in, which means you can respond appropriately to exactly the situation you're actually facing, rather than the situation you thought you might be in. That is the entire difference between handling this well and handling it badly. Knowing, not guessing, which set of rules applies to you in this moment. Let's talk about what comes next if the officer tells you that no, you're not free to go, because this is where most of the complexity lives, and where most people make the mistakes that cost them the most. If you're being detained, if an officer has told you directly that you're not free to go, or if they've made it physically clear through their actions that you're not free to leave, then you're in a Terry stop, assuming there hasn't been a formal arrest, and the first thing worth understanding is that a detention, by itself, is not an arrest. It's a temporary hold, and it has to be brief, focused, and connected to the specific suspicion that justified stopping you in the first place. Officers cannot hold you indefinitely under a Terry stop. They cannot turn a brief investigative detention into an open-ended interrogation just because they've decided to stop you. The stop is supposed to serve a specific investigative purpose, and once that purpose is either resolved or can't be developed further, the stop is supposed to end, one way or another. Here's what you're required to do during a Terry stop, and here's what you're not required to do, and please pay close attention to this distinction because it genuinely matters in a way that surprises most people. What you may be required to do in states with what are called stop and identify laws, and not every state has these, which is why the specific rules in your state are worth knowing in advance, is provide your name, and in some states, your address, and in some states, a brief explanation of your conduct. The specific requirements vary considerably from state to state, but in states where stop and identify laws exist, refusing to provide at minimum your name when an officer has a lawful basis to stop you can result in a charge of its own. So understanding whether your state has such a law and what it specifically requires is genuinely useful information to have before this situation ever comes up, not after. We'll come back to this point in more detail in just a moment. What you are not required to do, and this is where the rule at the center of this video really becomes concrete, is answer questions beyond the minimum identification requirement, and even then, only in states that actually impose that requirement. You are not required to explain where you've been. You are not required to explain where you're going. You are not required to explain who you were with, what you were doing, why you're in that particular neighborhood, why you're dressed the way you are, or anything else that officers might ask as part of building a picture of what's happening. The Fifth Amendment's protection against self-incrimination means you have the right to remain silent, and that right exists before an arrest just as much as it exists after one. It doesn't flip on only when someone puts handcuffs on you. It's available to you right now, on the sidewalk, before any of that happens, and you can invoke it. The way you invoke it matters, and this is one of the more nuanced parts of this entire topic, so let's go through it carefully. After a 2013 Supreme Court decision called Salinas versus Texas, courts have generally held that simply staying silent isn't enough to invoke your Fifth Amendment right, that prosecutors can sometimes comment on pre-arrest silence if you didn't actually invoke the right. What that means practically is that you want to say it out loud, not just go quiet and stare ahead, but actually say the words, "I'm invoking my right to remain silent," or "I'd like to exercise my right to remain silent," or even more simply, "I don't want to answer any questions." The specific phrasing is less important than the fact that you're making it explicit, that you're not just failing to respond, but that you're affirmatively choosing not to answer, which puts you in a much cleaner legal position if any of this ever matters later. Let's talk about what this actually looks like in a real moment, because the gap between knowing a principle and being able to apply it under pressure is real, and it's worth bridging explicitly. You're on a sidewalk. An officer approaches. You ask your first question, "Am I free to go?" The officer says no. You now know you're in a detention of some kind. Your next move is to stay calm. And I mean genuinely calm, not performed calm, because escalating the situation, or expressing frustration, or arguing about whether the stop is legitimate helps you in exactly 0 ways in that moment. Your job right now is not to win the legal argument on the sidewalk. That fight, if it needs to happen, happens in a courtroom, with an attorney, and with the full force of the legal system available to you. The sidewalk is not where you win the legal argument. The sidewalk is where you preserve your ability to make the legal argument later. So you stay calm. You say, clearly and politely, "I understand. I'm going to invoke my right to remain silent. Am I being arrested or am I being detained?" Those two questions, whether you're being arrested versus detained, matter, because they tell you where you are on that 3-part spectrum we started with. If you're being arrested, you now know that the full weight of your Miranda rights is in play, and your response is simple. "I'm invoking my right to remain silent, and I'd like an attorney." Say those two things and then genuinely stop talking, because everything else, every explanation, every context, every clarification you want to offer about why this is all a misunderstanding is something your attorney handles far more effectively than you do on your own in the moment it's happening. If you're being detained but not arrested, you now know you're in a Terry stop, and the framework is a little more nuanced because you have some limited obligations depending on your state, but you still have significant rights that don't disappear just because you're being temporarily held. Let's walk through those carefully. During a Terry stop, if your state has a stop and identify law, you'll want to provide your name when asked, because in states that require it, refusing can result in a charge of its own, which is a complication you don't need added on top of whatever else is happening. Beyond that minimum, you are generally not required to answer further questions, and you can say so. "I'm providing my name because I understand I may be required to. I'd like to invoke my right to remain silent as to anything else. That sentence is doing a lot of work. It shows you're not being obstructionist for no reason. It shows you understand there may be a limited obligation you're meeting, and it makes absolutely clear that your cooperation ends at the legal minimum, which is exactly where you want it to end. During a Terry stop, officers may also conduct a limited pat-down of your outer clothing if they have reasonable suspicion that you're armed and dangerous, not just because they stopped you, but because there's a specific, articulable reason to believe you might be carrying a weapon. This is sometimes called a stop and frisk, and it's worth understanding what it actually is and isn't. It's a pat-down of outer clothing for weapons only. It's not a full search. It's not a search of your pockets. It's not authorization to reach inside your clothing or remove items unless a weapon is actually felt. If an officer conducts a pat-down, you don't need to physically resist it, because physically resisting an officer, even one who's doing something legally questionable, is the kind of move that creates serious complications of its own, and it's never the right call in the moment. What you do is say clearly, "I don't consent to a search." You say it calmly, you say it out loud, and you let it be on the record that whatever happens next is not happening with your permission, and that fact matters if there's ever a question about it later. Let's talk about why the consent point matters so much in the specific context of a street stop, because it plays out a little differently here than it does at your front door, and understanding the distinction is genuinely valuable. On a public street during a Terry stop, there's a specific category of items that are sometimes found in plain view, visible in your hand, visible sticking out of a pocket, visible in some other way, and the legal treatment of those items is different from what's found in a full search conducted with your consent. If you consent to a search, if you say, "Sure, go ahead, I've got nothing to hide," you've dramatically expanded what officers can look through, and more importantly, you've made it very hard to argue later that anything found in that search shouldn't be used against you. If you don't consent to a search, and officers conduct one anyway, the question of whether that search was legally justified becomes a real question, one that belongs in front of a judge, with an attorney advocating for you, where it can actually be examined properly. Your refusal to consent doesn't guarantee a good outcome, but your failure to refuse consent almost certainly closes off avenues that might otherwise have been available to you. Let's talk about what you should never do during a street stop, because the don'ts here are just as important as the do's. Maybe more so, because the specific mistakes people make in these moments are so predictable and so consistently damaging that naming them clearly is worth doing explicitly. Don't lie to officers. This is worth saying right at the top, because the instinct to offer an explanation, and to make that explanation as good as possible, can tip into offering an explanation that isn't true, and that specific move opens up exposure to charges entirely separate from whatever the original stop was about. Lying to a federal officer is itself a federal crime. Lying to state or local officers can carry its own legal consequences depending on your jurisdiction. You are not required to answer questions, but if you do answer, everything you say needs to be true, which is actually one of the strongest arguments for simply invoking your right to remain silent rather than trying to talk your way through the situation. If you're not talking, you can't be lying. Don't physically resist. This one cannot be overstated. If an officer is doing something illegal, if a stop is not legally justified, if a search is being conducted without valid authorization, the place that gets corrected is a courtroom, not a sidewalk. Physically resisting or physically interfering with an officer, even one who's acting outside their authority, adds charges on top of whatever else might be happening, makes the immediate situation more dangerous for you, and typically doesn't actually stop whatever you're trying to stop in the moment. The case for why the stop was improper is made by your attorney, in front of a judge, with the full evidentiary record in front of them, not by you on a sidewalk in the moment it's happening. Stay calm, don't physically interfere, and preserve your ability to fight it later. Don't volunteer information. This is the one that catches people the most often, because the impulse when someone in authority starts asking questions is to explain yourself, to provide context, to make sure they understand the situation correctly. That impulse is completely human, and it makes perfect sense outside of this specific context. But in this specific context, information you volunteer is information you can't take back, and officers are trained to ask questions in ways that seem casual, but that are actually designed to gather information that can be relevant to an investigation. The question, "Where are you coming from?" sounds like small talk. It's not small talk. It's a question with a specific investigative purpose, and the answer to it becomes part of the record of this encounter. If you don't need to answer it, If you're not under an obligation to answer it, then not answering it is the right call, even if the answer itself seems completely innocent, because you cannot always predict in advance which piece of information is going to matter in a way you didn't expect. Don't consent to searches. We've covered this, but it bears repeating as its own standalone point, because it's that important. If an officer asks to search you, your bag, your backpack, your jacket, anything on your person, "Do you mind if I take a look?" is always a question you're allowed to answer with, "I don't consent to a search." Not no in a heated or confrontational tone, not a long explanation of why you're declining. Just, "I don't consent to a search." Calm, clear, and out loud where it can be heard. Don't make sudden movements. This is less about legal rights and more about basic safety in the specific context of a street encounter where an officer may be on edge for reasons that have nothing to do with you personally. Keep your hands visible, move slowly and deliberately, and if you're going to reach for something, your phone to show a picture, your wallet to retrieve identification in a state where that's required, narrate it first. "I'm going to reach into my pocket to get my ID." Okay? That simple step makes the encounter physically safer for everyone involved, including you. Let's talk about the role of identification specifically, because this is genuinely confusing for a lot of people, and the confusion is understandable, given how differently the rules operate depending on where you are. The question of whether you're required to hand over identification to an officer on a public street is a question with no single answer, because the answer depends entirely on your state's specific laws around identification requirements. Some states have stop and identify statutes that require you to provide your name, and in some cases a little more, when an officer lawfully detains you. Other states have no such statute, and in those states, during a voluntary encounter, you generally are not required to provide identification to an officer who asks for it, any more than you'd be required to provide identification to anyone else who asked on the street. Understanding which of these situations you're in before this moment arrives, knowing whether your state has a stop and identify law and what exactly it requires, is genuinely valuable preparation, the kind that costs you nothing to do in advance and potentially costs you a significant amount not to have done when the moment actually comes. Let's talk about what a reasonable suspicion actually needs to look like, because this is where officers sometimes push right up against or occasionally past the legal line, and understanding what the requirement actually means is what allows you to recognize when it's been properly met versus when it hasn't. Reasonable articulable suspicion, the standard that justifies a Terry stop, is lower than probable cause, the standard that justifies an arrest. But it's not nothing. It's not a feeling, not a hunch, not "there were some calls from this area recently" in isolation, not "you were walking away when I approached" in isolation, and not "you looked nervous when you saw me" in isolation. Those things can sometimes contribute to a totality of circumstances analysis, but none of them alone, and often not even in combination, rise to the level of a specific, articulable basis to believe that this particular person is connected to particular criminal activity happening right now. If an officer detains you and you can't figure out any legitimate basis for why, if there genuinely doesn't seem to be any specific conduct or circumstance connecting you to any crime, that's a fact worth preserving, which is why what you do after this encounter ends matters just as much as what you do during it. Let's talk about the minutes immediately after the encounter ends, because just like with a knock at your front door, what you do in the time right after the interaction is over matters more than people typically expect, and it's worth laying out carefully rather than just mentioning in passing. Find a quiet spot, pull out your phone, and start recording a voice memo, talking through everything you can remember while it's still fresh. What time it was, where exactly you were, how many officers there were, any badge numbers or names if you caught them, any vehicle numbers, what the officer said first, what you said in response, what questions were asked, what you did or didn't say in response to those questions, whether a pat-down was conducted, and if so, what happened during it, whether anything was removed from your person or your bag, how long the stop lasted, how it ended, whether you were told you were free to go, whether you were arrested, whether anything was said as the officer left. All of it. The reason this matters is the same reason it matters in every encounter situation. Memory fades, details blur, the specific wording that might be critically important gets lost in the broader emotional experience of the encounter if you don't capture it while it's still clear. And if the stop was improper, if the detention was unjustified, if a search was conducted without valid authorization, your own detailed, contemporaneous account of exactly what happened becomes one of the most valuable tools your attorney has when evaluating what options are available to you. Let's talk about recording the encounter itself, because this comes up consistently and deserves a clear, direct treatment. In most places in this country, you are legally allowed to record a police encounter, a stop, a detention, an arrest, as long as you're not physically interfering with the officer's ability to do their job while doing so. You can hold up your phone and record what's happening, because officers performing their official duties in a public space generally do not have a reasonable expectation of privacy in those interactions. Some states have two-party consent wiretapping laws that complicate audio recording in certain specific contexts, but the overwhelming legal trend, including court decisions from multiple federal circuits, has been that openly recording police in public is a protected activity. Practically speaking, if you choose to record, the most important things are to do it openly rather than secretly, to not put the recording above staying physically safe and compliant in the moment, and to simply keep the phone visible and recording without making the recording itself the thing the encounter escalates around. If an officer tells you to put your phone down, the question of whether that order is legally valid is another one that belongs in front of a judge rather than being litigated on the sidewalk. But understand that physically resisting that instruction in the moment has the same risk calculus as physically resisting anything else during a stop, and the recording can sometimes be recreated or corroborated by other means, while the complications of physical resistance cannot be undone. Let's talk about race and the reality of how street stops actually operate, because leaving this topic out of a video about police stops on the street would be leaving out something that's both documented and genuinely important. The legal framework we've been discussing throughout this video applies equally to everyone under the law, but the experience of being stopped on the street is not equally distributed, and pretending otherwise in a video meant to give people real, useful information would be a disservice. Studies, court findings, and reported data consistently show that stops happen disproportionately based on race in many jurisdictions across the country, and the legal principles we've covered, asking whether you're free to go, invoking your right to remain silent, refusing consent to search, staying calm and not physically resisting are, if anything, more important to have clearly internalized when you're in a group that faces higher rates of contact with law enforcement, because the stakes of handling the encounter correctly from the start are correspondingly higher, and the margin for error that much smaller. The law gives you these tools equally, regardless of who you are. Knowing those tools cold, before you need them, is how you actually get to use them. Let's talk about some specific versions of the street encounter that come up frequently and are worth walking through individually. Because the general framework we've built is important, but seeing how it applies to specific scenarios is how it becomes something you can actually reach for under pressure. Think about the scenario where an officer approaches you and says they've had reports of someone matching your description in the area doing something specific. This is one of the more common openers in a street stop, and it's worth understanding what it is and what it isn't. Someone matching your description is a starting point for reasonable suspicion, not a conclusion of it. If the description is detailed and genuinely matches you, and the reported conduct is specifically criminal, that combination might give an officer enough to justify a brief investigative stop. But a vague description, a description that could match half the people on the block, or a description connected only to behavior that isn't actually criminal, walking around, standing in front of a building, looking at something on your phone, that's a much shakier foundation for a stop, and the fact that you fit a general description doesn't obligate you to explain yourself beyond the minimum required by your state's identification laws. Your response can still be the same. Am I free to go? Followed, if the answer is no, by, I understand. I'm invoking my right to remain silent. The vagueness of the justification for the stop is a fact that can be examined later. Your job in the moment is simply to preserve your position, not to argue about whether the description is specific enough. Think about the scenario where you're stopped and officers quickly start asking about other people, who you were with, where they went, what they're involved in. This kind of questioning, designed to gather information not specifically about you, but about third parties, has the same answer as any other questioning. You're not required to answer it, and you can invoke your right to remain silent as to all of it. Being a witness doesn't create an obligation to provide information spontaneously on a street corner, and the fact that officers are asking about someone other than you doesn't change your right to decline to answer questions. I'm invoking my right to remain silent covers everything. Questions about yourself, questions about others, questions about events you may or may not have witnessed. Think about the scenario where a stop escalates, where what started as a few questions starts to feel like it might be heading toward an arrest, where an officer's tone shifts, where you start to feel like the situation is moving somewhere more serious. The most important thing in this moment, above everything else, is to stay calm. Not performed calm, not quiet, suppressed panic, genuinely calm, because calm is what keeps you safe, and calm is what keeps you making good decisions, rather than instinctive ones. Say clearly, "Am I being arrested?" You have the right to know. If the answer is yes, the response is immediate and consistent. "I'm invoking my right to remain silent and I want an attorney." And then you genuinely stop talking. Not mostly stop talking. Not stop talking, except to clarify one thing. Stop talking and let your attorney do the rest of it in the setting where that work can actually be effective. Think about the scenario where there are multiple officers, where you're surrounded or approached from multiple directions at once, where the physical setup of the encounter itself creates a feeling of pressure that makes it very hard to feel like you actually have a choice about whether to participate. This is worth acknowledging directly because it's a real experience that doesn't always match the clean theoretical version of "you can simply walk away if it's a voluntary encounter." When you're physically surrounded by multiple officers, the question of whether you're actually free to go takes on a different character, and courts have recognized that the totality of the physical circumstances matters when evaluating whether an encounter was truly consensual or whether a reasonable person in that situation would have felt free to leave. If you genuinely don't feel free to leave, if the physical setup of the encounter suggests you're not going anywhere, regardless of what you're told, then treating it as a detention rather than a voluntary encounter may be the more accurate legal characterization, and your response, asking directly whether you're free to go, invoking your right to remain silent if you're told you're not, is exactly the same, because the framework we've been building holds regardless of how many people are standing around you when the encounter happens. Think about the scenario where you're with other people, friends, family members, a group, and an officer approaches and starts talking to the group collectively or to you specifically while others are standing right there. The rights we've been talking about belong to you individually. You can invoke your right to remain silent, regardless of whether the person next to you is answering every question being asked. You don't owe it to your friends to stay quiet on their behalf, and you don't owe it to officers to answer because someone else in your group is being cooperative. Your response, your invocation, your non-consent to search, all of it belongs to you and applies to you individually, and it can't be waived on your behalf by someone else's decision to participate in the conversation. Let's talk about what happens if you feel like a stop has crossed a line, if an officer has detained you without what seems like any articulable basis, or extended a stop far beyond any reasonable investigative purpose, or conducted a search that you clearly didn't consent to and that doesn't seem to be justified by anything else. This is a situation where the gap between what you should do in the moment and what you might feel like doing in the moment is probably the biggest it gets throughout this entire video. What you might feel like doing is calling out what's happening, arguing about whether it's legal, demanding to know on what basis they're doing this. What you should actually do is continue the same framework we've been building throughout this video. Don't physically resist, don't raise your voice, don't argue about the legality of what's happening in real time, and keep everything that's happening in your memory as precisely as possible so that it can be accurately reported to an attorney the moment this encounter ends. Every detail, every word, every action, preserved as carefully as you can manage it, because that's where the case gets made, not on the sidewalk where it's happening. There's a version of this video that just gives you a list of rights and stops there. That version is easier to produce, and it misses the most important thing entirely, which is that knowing your rights in the abstract and being able to actually apply them in a moment that's physically uncomfortable, socially pressured, and emotionally charged are two completely different skills, and only one of them actually helps you when the moment comes. So let's talk about the emotional layer of this directly, because it deserves that treatment, the same way the emotional layer of a knock at your front door deserves it. Being stopped by police on a public street is designed, not necessarily intentionally, but effectively, to feel like you don't have a lot of options. The uniform is designed to convey authority. The question format is designed to feel like it requires an answer. The social dynamic of someone with a badge and the backing of the state asking you a question is designed, at every level, to produce cooperation, because cooperation is what serves the investigative purpose the stop is supposed to serve. All of that pressure is real, and recognizing it as a feature of the encounter, rather than a reflection of what you're actually required to do, is genuinely liberating in a way that's hard to describe until you've felt it. When you know that the discomfort you're feeling is the encounter working exactly as it's designed to work, and when you know that the right response to that discomfort is a specific, calm, practiced set of words, rather than an instinctive reach for explanation and cooperation, the pressure doesn't disappear, but it stops being the thing that drives your decisions. And that shift, that small but meaningful shift from reacting to applying a framework you actually know, is the entire difference between handling this well and handling it badly. Let's talk about something that deserves its own careful treatment: the moment right after you've invoked your right to remain silent. Because this moment is one that a lot of people don't know how to sit in, and the instinct to fill it in a way that undermines the invocation is extremely strong. You've said, "I'm invoking my right to remain silent." The officer keeps talking. They ask another question. They say, "Just answer this one thing." They say, "You'd be making this much easier on yourself if you just told us what was going on." They say, "If you've got nothing to hide, why won't you answer?" Every single one of those things, and every other variation of them, has the same answer, which is silence. Or at most, a brief, consistent repetition. "I've already invoked my right to remain silent." And then silence again. Not a new explanation of why you're staying silent, not an engagement with whether the question seems reasonable, not a response to the suggestion that you're making things harder on yourself. Silence, or the single sentence that reaffirms your invocation, and then silence again. This is one of the harder things to actually do in a real encounter, and it's worth practicing, literally practicing saying that sentence and then stopping and sitting with the discomfort of the silence that follows. Because the discomfort of that silence in a low-stakes practice moment is a much smaller version of what you'll feel in a high-stakes real encounter. And having actually sat in it before makes it much easier to sit in it when it actually matters. Let's talk about attorneys specifically, because they've come up throughout this video, and it's worth spending a moment on why they matter so much, and what the practical landscape for accessing one actually looks like. If you're arrested, you have the right to an attorney before questioning, and if you can't afford one will be appointed for you. But appointed attorneys in the public defender system are often overworked and under-resourced, and if you have the ability to retain private counsel, it's worth knowing in advance who you'd call and how you'd reach them, rather than figuring it out for the first time from a holding cell. If you're detained but not arrested, you're not yet at the point where an attorney is physically present, but you still have the right to not answer questions, and simply saying, "I'd like to speak with an attorney before answering any questions," is a complete, legally meaningful statement that serves the same function as the invocation of your right to remain silent. It puts a clear marker in the record about your intentions, and it makes explicit that whatever happens next in terms of questioning is happening without your cooperation. Let's talk about one more specific scenario before we pull everything together, and that's the scenario where the street stop involves your vehicle being searched. Because the rules around vehicle searches are close to, but not identical to, the rules around street stops involving only your person. If you're stopped on the street and you have a vehicle nearby, parked, close, associated with you in some way, officers may try to extend whatever basis they have for the stop to your vehicle as well. A vehicle search generally requires either a warrant, your consent, or what's called probable cause to believe the vehicle contains evidence of a crime, a different and somewhat lower standard than the standard for searching a home, but still a real standard that has to actually be met. The same rule applies here that applies to every other version of a search in this video. I don't consent to a search of my vehicle. Say it clearly, say it out loud, and then don't physically resist whatever happens next, because your refusal to consent is preserved in the record regardless of what officers decide to do after you've stated it, and that preservation is what matters later when an attorney and a judge are looking at whether the search was actually justified. Let's bring all of this together now, because after covering as much ground as we have, the most valuable thing to leave you with is a clean, clear, portable structure. Something you can actually recall and apply under pressure, rather than a long, complicated list of specific rules that's hard to hold in your head all at once. When an officer approaches you on a public street, before you explain anything, before you answer anything, before you offer any information at all about yourself, or where you've been, or what you've been doing, ask the one question that tells you everything you need to know about what kind of encounter you're actually in. Am I free to go? If yes, you're in a voluntary encounter, and you can end it politely. Right then, walk away calmly with a simple thank you, and that's the end of it. If no, you're in a detention of some kind, and you now shift to the next layer of the framework. Say clearly, I understand. I'm invoking my right to remain silent. Am I being arrested or just detained? The answer to that question tells you whether you're in a Terry stop or a full arrest, and either way, the response is the same family of actions. Provide minimum identification if your state requires it, and nothing more. Don't consent to any search, don't physically resist anything, and genuinely stop answering questions beyond what's legally required. If you're arrested, add "I'd like an attorney," and then actually stop talking until you have one. That's the whole framework. Ask whether you're free to go. Know the answer tells you which rules apply. Invoke your right to remain silent. Don't consent to searches. Don't physically resist. Preserve everything you can remember for afterward. Talk to an attorney before doing anything else. Let's say the key sentences out loud one more time, because hearing them in your own voice is different from reading them on a screen. And the more times you've actually said these words, the more readily they come when you need them for real. Am I free to go? I'm invoking my right to remain silent. I don't consent to a search. Am I being arrested or detained? I'd like to speak with an attorney before answering any questions. 5 sentences, calm and complete, that cover the essential moves for virtually every version of this scenario you're ever likely to encounter.
All right, that's where we'll leave it for today. I hope this gave you something genuinely useful, not just interesting to hear, but something you could actually use if the right situation ever came up. That's always the real goal here, understanding you can actually carry with you, not just information you forget by tomorrow. Take care of yourself, know what's actually yours, and I'll see you in the next one.